that are just joining us. This is Dr. Ugone. Dr. Ugone is a senior advisor at Analysis Group. Having testified at trials and depositions more than 500 times, Dr. Ugone specializes in the application of economic principles to complex business disputes, and he's experienced in economic and damages-related analyses. He's provided financial and economic consulting services in cases involving antitrust, breach of contract, class certification, IP, professional negligence, and security-related issues. Today, Dr. Ugone is going to give us a wonderful start to the symposium with a review of damages in IP litigation. So without further ado, Dr. Ugone, thank you for joining us. Let me check if your video is on, and if it is, I will pin you so that everybody gets to see you. There you go. You are live, Dr. Ugone. Thank you.
All right. Well, Roy and Caroline, I appreciate being invited to talk today. And so hopefully everybody can hear me clearly. And as Roy was saying, I was asked to kind of, talk about damages in IP litigation. And I'm going to do that. I've taken some liberties with the topic. So I decided to not only include, just descriptions of a little bit of a primer and how to do certain things, but I'm also attempting today to show, even if you think you're doing some simple calculations in a damages context, that there can always be, some potholes in the road that you've got to be careful about in the damage quantification process. But within that kind of smaller subset of what I'm going to talk about in terms of just the primer aspect, and I'm assuming we have a diverse audience here of people that may be very familiar with what I'm going to say, but I think they'll be interested in some of the higher level things I'm saying, of areas to watch out for. And there may be some people that are more novices in the area, and I think they'll find hopefully what I'm going to say to be a good introduction for them as well. But I'm not just going to talk about, the mechanics of damages. I'm also going to talk about a little bit about, presentation skill sets that are needed, and basically how you can put a good presentation together. I mean, ultimately, the objective on the plaintiff side is obviously to win your case and to get, the proper monetary remedy. And on the defense side, it's almost the same objective, to win the case, and or if liability is found, to make sure that the damages is the appropriate amount. So that involves often more than just the mechanics. It involves, the presentation of what the calculations show as well. So I'm going to include, so let me turn a page here. So hopefully, there we go. So I'm giving a little bit of an introduction here as to what my presentation is going to cover. So it's more than just a review of the damages in IP litigation. It's going to cover, like I said, kind of the environment in which those calculations take place as well. Now, by way of background, Roy was very kind in what he said about me, but I've been doing this for about 35 years now. I first started working in the litigation environment, and I call myself a forensic economist and damage quantifier. But I've been doing this for about 35 years, and I first testified in 1990. And unfortunately, I'm probably up to like 550 testimonies of depositions and trials, including 6 already this year by video depositions. Now, everything in 2020 got pushed. Everybody had this bright idea of, why don't we move everything to the first quarter of 2021? So suddenly, there's a whole bunch of depositions that are taking place currently. So I kind of have that experience too, if anybody wants to ask questions about that. But as we see in number 3 there, I'm going to talk about damages and more. The usual caveats apply. I mean, it's always, I'll be upfront with you, it's always a little dangerous when a damage quantifier, gives a presentation such as this, because I've had situations in depositions where an opposing attorney has listened to something I've said, and then in a depo, they'll say to me, well, do you agree with the following statement? And I'll go, I think I do, because I think I said that. So what they had done is actually kind of copied something down I had said in in a presentation. But I'm going to try to be, as forthright as possible. We're all professional here, and hopefully nothing I say will ever be used against me, but you never know. But I'm prepared for that, because I always try to be, consistent in my analyses. But we're also going to have a smattering of war stories and other distractions. And as we go through, you'll see some kind of hidden messages that I want to kind of communicate as we go through sort of the presentation here. Now, I'm not quite sure how it would work, but number 6 there, questions. I mean, feel free to ask a question at any point. I'm not quite sure how that gets to me, but if I can, I'll address it right then if it makes sense, or if we need to save it till the end, we can do that. And I've also put some questions of my own, kind of thought questions at the very end if we don't have any questions and if we have time. Now, the interesting thing is I've already, I'm going to do a little economist humor here, but, it's funny because I agreed to give a presentation from 9 to 10:30, which is an hour and a half. And I've already broken one of my rules, because one of my rules is that an economist at most can only be interesting for an hour. And here I agreed to do an hour and a half presentation. So we'll see what happens. But I'll get started here in a second. But my last video deposition, this tells you about how interesting an economist can be. I was giving the video deposition, and about halfway through, with everybody in different locations, all of a sudden we start hearing this snoring. And it turned out that the videographer, who's in a different location, had actually fallen asleep and was snoring on the tape. And we're going, Rick, to try to wake him up, but we couldn't wake him up. We finally had to take a break, and somehow they got him awake. But I'm going to try to prevent that from happening. So if you feel the need to start falling asleep or snoring, probably go on mute so we don't hear that. Obviously, the world has changed. Everybody's heard about the $2.175 billion verdict that came down recently. And, that's probably going to permeate all the way through all the presentations today. I was looking at the titles of some of the other presentations, and I'm sure, there's going to be a discussion about that as well. Anyway, those are just kind of my opening comments, so you know what to expect as I go through. And, obviously I'll get started here, but, I think everybody knows this. There's different types of, intellectual property type cases, patent infringement, copyright infringement, trademark infringement, theft of trade secrets, trade dress infringement. And over the course of my career, I actually have testified in all of these areas, I believe, but mostly in patent infringement and theft of trade secret cases, and sort of trademark infringement, to a lesser degree in trade dress and copyright infringement. But I do have a fair amount of experience in the other three. But today we'll be concentrating more on the patent infringement side, but I will be making comments about monetary remedies in some of the other causes of action as well within the intellectual property kind of umbrella. So, I thought we'd start off with a bit of history. I mean, if you look at this article here, I pulled up an article from September 2006. Now, there's kind of a changing of the guard here. There's going to be obviously everybody's predicting a movement, and I think others will talk about that later in terms of where cases may be filed. But this goes back to September 2006 in the New York Times, where it talked about, this little town of Marshall, 150 miles east of Dallas, becoming a red hot, patent docket, and going from, 32 cases in the entire Eastern District of Texas to, by 2006, 234 in the district, the majority of them in Marshall. And they talked about some of the reasons for that. But the reason why I kind of wanted to bring that up is that was the starting of the sort of explosion in patent infringement cases in Texas. But it's kind of interesting because I made a career enhancing move, and I'm going to tie all this together for you in a second. But around 2000, quite by happenstance, I happened to move to a little town called Grand Saline, Texas, which is about halfway between Dallas and Marshall, but very close to Tyler. You know, and everybody knows in the Eastern District of Texas, you've got Tyler, you've got Marshall, you've got the other cities that comprise, you know, the Eastern District of Texas. But so I ended up having a place where I live, you know, that was very close to, you know, what was developing as areas that, you know, would have a lot of patent infringement cases. So it wasn't planned, but frankly, because I lived in that area, I started getting retained back in 2006 on a lot of patent infringement cases. And I've got a map there that shows you, you know, where But in that picture at the very bottom, you see the gray hood of my truck at the time. I had a Dodge truck. And it's kind of interesting because I was in a fairly big trial in the Eastern District. Witness just said it would fill up the back of his pickup truck. I'm going to let the summary document it in. So that truck ended up helping us win the case when I was able to describe the amount of documents that were in this one summary document that would fill up the back of my pickup truck. The other thing that's kind of interesting here, and sometimes this is an advantage of having a local expert if you can do it. So you can see I'm touching on a bunch of different things here, communication issues, maybe sometimes the value of, you know, who your expert is, you know, even on the damages side. But if you're familiar with that area of Texas, in Canton, Texas, so if you look at the little circle of Grand Saline and then go south and to the left a little bit, you'll see a little town called Canton. Well, you may or may not know that Canton has like the largest swap meet flea market in the world once a month. It's called Trade Days or First Mondays. And if you live in Tyler, you know, everybody in that area goes to this swap meet, so everybody knows about it. And so the way I use that is that, like, if I'm testifying in Tyler, there's two ways you can get to Canton. As you can see on the map, you can go on I-20, or what's not on the map, there's Highway 64. And those are basically parallel, and they take the same amount of time. So you can go to Trade Days, which everybody does, either through I-20 or Highway 64. And so if you think about it, that's my example of the concept of a non-infringing, acceptable non-infringing alternative. I tell a story how, you know, if you're in Tyler and you want to go to Trade Days, you can either take Highway 64 or you can take I-20. And what would suddenly happen if somebody put a toll on Highway 64? Well, depending on, you know, the amount of the toll, you might continue to take Highway 64, or you may decide to take the alternative, I-20. And it ends up always kind of working very well because non-infringing alternatives and acceptable non-infringing alternatives are important in, you know, obviously patent infringement cases. But here's a very simple way, just sort of knowing the geography of the area, that you can communicate to the jury, you know, what could be a very difficult concept and how the amount of the toll or the royalty may impact a decision that's made. And frankly, they can, you know, the jurors can internalize that and understand it, you know, very easily. So, you know, I'm not getting into right now the mechanics of how you do calculations, but I'm just kind of giving a few war stories about how you can make, you know, that damages presentation at trial, you know, go a little bit more smoothly. And I just wanted to give you that little example of where I live and some of my little trade secrets that I that I try to do at trial, just to make sure that the jury's understanding, what I'm trying to communicate to them. Some more preliminaries I thought we'd kind of go through. If you really think about it, since we're starting to morph more into the damages, that especially in, patent infringement cases, more than other causes of action, I mean, there really is what I call a multidisciplinary approach, that has to be taken, that there's a lot of different skill sets. And what I'm trying to do in the presentation here is also just kind of motivate you thinking about how you would approach, the damages question, and, what skill set do you need? Do you need a real specialist, or do you need I don't mean anything derogatory by saying a generalist, but somebody that can cover all of these areas. But as you can imagine, in a patent infringement case, there's accounting expertise that's needed. Somebody's got to be able to look at financial statements and figure out, what's the profitability of the product, if damages are going to be claimed for lost sales, or if you need to know the profitability as an input into what a likely royalty payment might be. You've got to understand the profitability of the product. That's a little bit more of an accounting type issue. But there's also more, pure economic issues. What's the market? Who are the competitors? What are the competitor impacts? What are the relative market shares of all the parties that are involved, and also of the competitors? Finance, what's, if there's a future income stream involved, what's the riskiness associated with a future income stream? If you have to do any discounting back to a present value. So I'm starting to use a little bit more jargon here, but that's where, the finance capabilities come in. It's not uncommon that surveys, statistics, and econometrics are used. How do you properly design a survey? Sometimes you've probably heard some of these terms. A conjoint survey or conjoint analysis might be used to try to find out people's willingness to pay for a certain, attribute of a product, and that attribute may embody a patented feature, for example, or one of the claims of the patent that's in dispute. So, there could be survey, statistics, or econometric skill sets that are needed. But, and then it all comes down to, ultimately, when this is all said and done, in the damages side, and I'm sure this extrapolates to other experts and witnesses as well, but you've got to take all this complicated stuff and turn it into, a written report that can be easily understood. So, writing and communicating properly is an important skill set as well. And then finally, just when you get to trial, can you verbally explain complicated concepts to maybe the uninitiated jury in an easily understandable fashion, so that they're, persuaded by the damage, model that you're putting forth, or the critique you're putting forth. So all I'm trying to do with this slide is make sure, that when you're thinking about the damages side of your case, that you think about, the weights you want to put on each of these skills that are needed, in your damages expert, and at least so that you're aware of them. This isn't saying, hire an accountant over an economist to do a calculation, but it's more of like a Venn diagram, that some skill sets are going to be stronger in some areas rather than other areas. And you may want to take that into account when you're, deciding upon your expert. So I thought I'd give you a little bit of an introduction there to that. This is kind of funny. I live out, where there's more cows than people in Grand Saline. And I often stop at truck stops when I'm driving from Dallas back to Grand Saline. And I stopped at a truck stop, and at one of the little, in the restaurant, they had these little sayings by philosophers and psychologists and so forth. And so I had never heard of this person before, that, maybe that's saying something, but Abraham Maslow had said, to the man who only has a hammer, everything he encounters begins to look like a nail. Now, I put a little note there. I'm not entirely sure what that means, but I think it's applicable here for everything that I just said, that you want to make sure you have, the right skill set for your, for whatever calculations you have to do. But it's kind of hard to understand that, but I know it's applicable, but I'm not quite sure I can interpret it for you. But anyway, I thought that was kind of interesting. At this point, when you get to damages, there can be a lot of different jargon that can be used, and you have to be careful. We've got lost sales analysis, we've got incremental cost analysis, you've got reasonable royalties, you've got a hypothetical negotiation, you've got all of these terms that are going to be foreign to the jury. So it's really important that your expert have some good communication skills. And I've got a cute little clip here from the movie Armageddon, which is one of my favorite movies. But it's when they're trying to explain to the President of the United States that this asteroid or meteorite is headed towards Earth. So this has analogies to everything that I thought that I had kind of brought up, and why communication skills are important. So what I'd want to point you to is the first and second explanations to the president of what's happening, versus finally when Billy Bob Thornton jumps in and says something the president can understand. And the funny part is, look at Billy Bob's look that he's giving to one of the people in the film who tried to do an explanation. That's kind of funny too. But let me see, I'm going to try to do this. It's going to require me to kind of go back and forth, but I'm going to do my best, and Roy may have to jump in here to save me, but I'm going to try to do my best here to switch to this video.
I'm here, no worries.
Let's see. Now somehow I have to share my screen again.
Right, get back to your Zoom window and then press the share screen button. And make sure that little checkbox is ticked, remember.
All right, let's try it.
This is the anomaly at 1643. Here is the anomaly at 1658. And here is the anomaly at 1700.
Enough with this anomaly horseshit. What is this thing?
It's an asteroid, sir.
How big are we talking?
Sir, our best estimate is 97.6 billion.
It's the size of Texas, Mr. President.
Yes, sir.
All right, if you can hear me, I'm going to try to get back to my presentation, so just bear with me. Roy, am I back?
No, sir, you need to stop your screen share.
Okay.
There you go, and then restart it. So back on Zoom, do share screen again.
Okay. How's that? Am I back?
You're back.
Okay. All right. Anyway, my analogy there was, this one guy tried to say it was so many zillions of tons heading towards Earth, which nobody would understand. Billy Bob Thornton says, well, it's the size of the state of Texas, which people can understand. The way I'm bringing this full circle, that's kind of the equivalent of, when the judge had asked me how many documents I had, I didn't say I had so many, gigabytes of documents or so many pages. I said it would fill up the back of my pickup truck. And that was something that, was understandable. So, I'm just trying to drive home the point that, with damages experts especially, it's not only important to get somebody that's technically competent, that absolutely is important, but you also need somebody that can communicate properly to the jury. I'm just going to give one more example of this. You know, some people say, well, I wouldn't do that. But I'm going to turn to one of my other favorite movies, and that's The Matrix. And hopefully everybody's seen The Matrix. And if you remember The Matrix, there's all these kind of like numbers going by on the screen. And if you've seen the movie, hopefully nobody finds this offensive, but if you've seen the movie, that what you're looking at is really the woman in the red dress, but you don't know that because you're seeing all the code, behind, what's happening in the Matrix. And the reason why I'm showing you this is people don't know it, but at trial, they're showing this code to the jury. And I'm going to prove that to you. So here's the Matrix, which we don't understand. And then what do we show the jury? We show the jury that, and if we just kind of go back and forth, we're really just kind of showing all this code, to the jury. And so that's not really communicating in the best way possible, what the concept we want to get across, when we can actually make it much simpler, that if we're talking about R&D, can put this picture of a machine that is doing the R&D, and here's the actual R&D investment. Here's an alternative calculation. But, we should always try to make sure that our demonstratives that accompany the damages analysis is, something that the jury can comprehend and not fall into the trap of either Armageddon or the Matrix example that I was showing you. I'm gonna, well, maybe not skip over this. The other way you can think about, using a damages expert too is, now this is all from a damages expert's perspective. I'm not saying that this is, exactly how a lawyer may look at things, but this is sort of the life cycle of a litigation engagement from a damages expert perspective. There's, the wrongful conduct, there's, the legal proceedings, there's fact discovery, data document management. We're going to be talking about number 5, the damages analytics, but then the report, discovery, motions of trial, and so forth. But think about how, the damages expert can help you in each of these areas, because the damages expert really can help you in fact discovery to make sure you get the right documents, that you have the right interrogatories, that on the 30B6 witnesses or the fact witnesses, you're asking the right questions such that the damages expert will have the proper anchors and foundations for the calculations that need to be done. So that's kind of the message here. A lot of things happen at trial. This was kind of an interesting thing that happened to me once on my way to testify. So unfortunately, it's hard for me to see because I've got some pictures that are showing up on the right-hand side that are covering the good and the bad, but I'll try to remember what's there. But this was a day in my life at a trial when I was supposed to testify. So I was on the way to the courthouse, and that was a good. Unfortunately, I got pulled over for speeding. That was a bad. The policeman saw on my front seat that I had legal documents in my reports and asked if I was going to court. And I said, well, yeah. And so that was sort of good. They carried weight with them. And he ended up just giving me a warning instead of a ticket. So that was a good. Then on the way to court, I stopped and got a cheese bagel sandwich. So that was, things were happening okay. Except when I was eating the bagel, I felt something. I realized that my side front tooth fell out and I had swallowed it. So that was a bad, and I was supposed to be testifying, and now I was going to be testifying without a side front tooth. But luckily I was able to get a dentist appointment for the next morning. So that was a good. So I attended trial, but I didn't have to testify that day. So that was a good. Got back to my car, except in the rush of things, I forgot to pay for the parking. And so when I got back, there were 2 of those boots on my tires. So that was a bad. And I had to pay $128 to remove the boots instead of $15 for parking. That was a bad. And then I tried not to kill the messenger. And then I headed back to the office to start the second shift. But luckily, I got my tooth fixed and I was able to testify the next day. But all kinds of things can happen to get in the way of testimony. But I think what I'm trying to say here too is that proving damages in an IP case really is a team sport. You know, I don't think you can just rely on one person or just rely on the damages expert. And I call it predicates. In other words, before I testify, I've usually given a list to the, to my counsel that I'm working with. And I usually am telling them, look, I need the following witnesses to say the following things as predicates. So when I get up there to testify, it's not the first time the jury is hearing it. Or if I'm on the defense side, I need you to establish the following things in cross, on the plaintiff side. So again, the jury isn't, hearing it for the first time when I testify. So keep in mind that it's a team sport. Everything needs to be integrated. Sometimes I find that, maybe the liability or the infringement team, is not always for these purposes, staying as close or as coordinated with the damages side, when in fact they're all interwoven, and the damages person often has to rely on the technical experts and some of the fact witnesses as well. So always make sure that you establish the predicates for your damages expert as well. This is the scary part at trial. This is the first courthouse I testified in. I really felt like I was walking to the gallows when the first time I walked up those steps to testify. And you've got to make sure your damages expert is confident and prepared, and you've gone through all the potential cross, because that person really is all alone on the stand there. And that can be scary if the person's not, if the person's not prepared. Now I just wanted to kind of give a flavor of some different things that I think about the environment in which, the damage calculations, take place. So I kind of wanted to give you that background. But now we can maybe get into some of the, the mechanics a little bit of, of patent infringement damages, for example. So let's turn to that. So, as you can see here, everybody knows the statute that basically the court, if there's a finding for the claimant, the court shall award claimant damages adequate to compensate for the infringement, but in no event, less than a reasonable royalty. So pretty much, everybody knows that. Your damage quantifiers will know that. And in patent infringement cases, that usually, leads to sort of two primary remedies that are available, kind of lost profit damages and reasonable royalty damages. So this is the segue from, just talking about some of that background stuff to getting into a little bit of the meat and the mechanics of some of the calculations. And we'll start off with lost profits damages first, and then we'll kind of get into the reasonable, reasonable royalty damages. I don't know if there's been any questions or not, but maybe not, but I'll continue. But maybe I'll just take a 10-second stop there to see if there's any questions about anything I've said up to this point. And I'm more than willing to, answer any questions if we can kind of pull that off, with the technology, but I don't know if there's any questions.
So no questions have come in, but I'll just use this as a reminder. For everybody that's just joining us now, hi, I'm Roy. I'm the symposium editor for Tipple J. On the bottom of your Zoom window, where we are currently looking at Dr. Ugone's presentation, there should be a little button that says Q&A. Feel free at any time to type in some questions in there. They will pop up and I will relay them to Dr. Ugone. But Dr. Ugone, at this time, there is not any questions. There are not any questions.
Okay. All right. And hopefully there's no snoring either. So we'll continue. A couple of things, I went back to the Marshall story back in 2006, and yes, there's a changing of the guard. I think there's going to be some shifting, but, I find, at least from a damage quantifier perspective, and it may be different from an attorney perspective, but patent infringement cases, more than any other cause of action, rely on sort of case opinions for guidance as to how you do certain calculations or what you need to take into account and what you need to be careful about. Now, I didn't put, obviously some of the most recent cases here because I just wanted to kind of, make the point that there's still a lot of cases in the past, that are very important, even though, I find in the intellectual property arena that there's always movement in cases and there's new cases that come out that give guidance. But, today I just wanted to list these out there. We're going to be talking about Panduit. We're going to be talking about Georgia Pacific. We're going to be talking about Moreflow, and we'll get into those. But I just also wanted to say, there's a lot of older cases that, one should always keep in the back of your mind. And I might also suggest that, you want to make sure that your damage quantifier is familiar with these concepts as well. Also, just always kind of keeping in mind the various monetary remedies before we get into the calculations here. I've talked about lost profits and reasonable royalties. Well, in a patent infringement case, you can also, there can be price erosion claims as well, which one could put in under the, the lost profits. But there's times that you might even be able to make that argument within reasonable royalties, that you don't want to set up a situation with a royalty payment structure such that you could end up finding yourself in a, price competitive situation. So I just wanted to say, even though we'll be concentrating on lost profits and reasonable royalties, that one also can be thinking about price erosion. Over on the right-hand side, there's just other remedies for, other types, causes of action. I mean, clearly you can think about, theft of trade secrets where there can be a disgorgement of profits. And some people may even want to talk about a diminution in value of a company. And then again, on the left-hand side, sometimes you can use your damage quantifier for a, support for an injunction motion or, a commercial success argument. So there's a lot of different ways that what we're going to talk about can come into play. So let's just start with sort of lost profits damages. So you've got, let's say, a competitor to competitor situation where the patent holder or the plaintiff in this situation, this example, is accusing the defendant of infringing a patent, and the plaintiff wants to establish a lost profits damages claim. Well, the home base that everybody essentially turns to is the Panduit case. And really, here's where I want to mention some things and give some guidance as well. But and I'm sure the audience is familiar with Panduit, so I'm just going to go through those, but then also say some areas, where you have to be careful with Panduit. But under Panduit, there's four prongs that have to be, you have to satisfy the court in order to, or the trier of fact, in order to make a claim for lost profits. That's that demand exists for the patented product. Now, there's always a lot of debate over that. Is it demand exists for the patented product, or what about demand for the, the patented feature as opposed to the whole product? But, I'll leave that up to the attorneys kind of to debate over that. But my experience generally is that it's literally what it says: demand exists for the patented product. But, I also think that you can take some, I don't want to say liberties with that, but also talk about whether demand exists for the, the patented invention in a multi-featured product as well. Although Panduit literally says demand exists for the patented product. Now, the second factor is the absence of non-infringing alternatives. I usually kind of think about that a little bit more broadly in terms of, is there an economic causal link to lost sales? Now, something that can break that economic causal link to lost sales could be the existence of non-infringing alternatives. And I'm not going to try to get into, the head of the court and say what they really meant by that. But sometimes you might be able to say, well, okay, we're talking about non-infringing alternatives, but what we're really trying to look at is whether one can establish an economic causal link between the alleged wrongful conduct, the infringement of the patents in suit, and ultimately an economic link to whether the plaintiff has suffered diminished sales or not. And then, it goes from there that, okay, when you start, looking at this and doing your calculations and you're coming up with a, kind of a lost profits claim, and we'll get into this, but there's usually what's called a incremental sales analysis or a lost sales analysis. You're building a damage model. Those are kind of synonymous terms. You ultimately also have to do a cost side analysis. But the question is, whatever projections you're making, could the company have actually met, could the plaintiff company have met the output levels that you're saying would have existed in the absence of the infringement? So could they have manufactured the additional units, and did they have the marketing capability to sell those additional units? So that's almost like a cross-check, or I view it as a cross-check on the calculations, so you don't sort of run amok and make, in a sense, too big of a projection, something that, the company would not have been able to handle, and hence would lead to sort of an unreliable estimate of claim lost profits damages. And then there's, this issue of, can lost profits be reasonably quantified? I'm going to give some good examples of that a little bit later. But basically, can you come up putting all of this together? Can they be reasonably quantified or reliably quantified in terms of what you're putting together? Now, both with Panduit and ultimately when we get to the Georgia-Pacific factors, sometimes there's the danger that a damages expert could end up taking what I call a cookbook approach or a checkmark approach. Let me just, check mark each of these items, and okay, I check that one off, this one off, this one off, and I get lost profits. But if you think about it, each of these considerations, again, whether it's on the lost profits Panduit side or when we get to Georgia-Pacific and the Georgia-Pacific factors on the reasonable royalty side, they can actually go quite a few layers down in terms of the analysis. So I'd encourage that whenever you're working with your damages expert, make sure they're not taking what I call a cookbook approach or just a check marking approach. But let's go a little bit further. I like to simplify the world down on the lost profit side really to two questions. And I know we've got the Panduit factors, and I know that the trier of fact is going to want to see those, and the court is going to want to see those. But sometimes I try to just simplify the analysis down to just two questions. One, would the defendant have made less sales in the absence of the alleged infringement? In other words, would the defendant, without infringing, would they have made less sales? But that still doesn't mean that the plaintiff has lost profits yet. It just means the defendant would have sold less. So then you have the second question. Would the plaintiff had made more sales in the absence of the alleged infringement? So first you have to establish the defendant would have sold less. Then you establish that at least some of those sales would have flowed to the patent holder or the plaintiff. Then intuitively, I like to think of it intuitively, then you can be more confident in the lost profits claim that you might be putting forth. So all I'm just trying to encourage here is sometimes, we've got all these case opinions, things can get complicated, but I like to try to say, hey, can we simplify it down to something that's easily understandable and intuitive? Would the defendant have sold less? Would the plaintiff have sold more? And if I can have empirical and economic anchors to answer both of those questions, either yes or no, then I can be more confident and have a more reliable presentation, that I'm going to give to the trier of fact. So I'm just trying to encourage, there's different ways that addressing what you have to do in these sort of situations. Let's just get into the mechanics a little bit here. So when you talk about lost profits, you're building a lost profits model, and in its most simplest form, it's got two components. What are the incremental sales? In other words, when we said, would the plaintiff have made more sales in the absence of the infringement? That's what you're trying to figure out here. What are the incremental sales? That's called a lost sales analysis or a lost revenue analysis. So you have to do that component of the damage model. How much more in terms of unit sales and revenues would the plaintiff have received? But that's not damages yet, because there's costs of production. In other words, if they to sell more units and to take in more revenue, they would have had to incur costs to make those units. And so you've got to figure out the incremental costs and do an incremental cost analysis to subtract from the incremental revenues, and that ultimately gives you your lost profits. So that's sort of the foundation. Things get very, very complicated. There can be pages and pages and equations all over the place. But in its essence, this is, what you're trying to do in a damage model for lost profits. Now, it's always good to look at the mirror image of work you're doing as a damage quantifier. So here, when I say the plaintiff, talking about the patent holder, obviously, and the defendant is the alleged infringer. So let's not get confused if sometimes the captions are kind of reversed. But as I just said, the job of the plaintiff, is really the hard job. I find, when you're on the plaintiff side, that's tough, because you got to build that damage model. You've got to do that lost sales analysis. You got to do that incremental cost analysis, come up with the lost profits, and you've got to have a solid anchor for everything you're putting into that model. On the defendant side, really what you're doing is critiquing that plaintiff's damage model. And sometimes that just means I've just got to find the 1, 2, or 3 weak points in that model. So the plaintiff's got to make sure, everything. I'm going to be perhaps emphasize this a little bit too much, but the plaintiff almost has to be perfect in terms of what they put together. They don't want to have a little hole or an opening for the defendant. The defendant just has to find that little gap in the logic or something that doesn't quite have an empirical anchor, so that they can say, look, there's three things wrong with this plaintiff's model. And if I take one of them away, damages go down by 50%. If I take 2 of them away, it goes down by 80%. If I take all 3 away, there's no damages. The other thing that a defendant can do is investigate alternative reasons for whatever decline in the business that the plaintiff might have experienced. So that's another thing to kind of keep an eye on, and that's what a defendant expert will try to do. And then sometimes the defendant will also come up with an alternative number or an alternative damage model. Now that could take the form of just adjusting the plaintiff's model, or the defendant could build their own model. But one reason why I'm just kind of simply putting these forward on this page is, if you're on the plaintiff side, I always think it's good to think about the mirror image. What's the defendant going to be doing? And if you're on the defendant side, what's the plaintiff going to be doing? And then obviously you'd be better equipped, to make sure that you don't run into any of these problems that I'm alluding to. Let me just give you an example of how this might work. So here, I've got kind of a sales pattern in revenues. I've got years along the bottom, year 1, year 2, year 3. And you can see that initially through year 4, sales are increasing. So there's dollars on the left-hand vertical axis, those are dollar sales. And the horizontal axis is time. And the line represents actual revenue. And you see an increase. And then you see a dip down. And then you sort of see a recovery period. And so that might be the base numbers that the let's just say the plaintiff damage quantifier is starting with. So you want to make sure you get all that information, through the discovery process. So I'm circling back to, at the very beginning when I talked about the life cycle of a litigation engagement. So you want to talk to your damages expert early on to make sure you get all the information you need for this beginning point of the damage model. But from there, you've got to figure out, well, what would have happened in the absence of the infringement? So what you're doing is you've got to figure out what's the damage period. Over what period of time, has the plaintiff been impacted by, the alleged infringement? Now, sometimes there can be a beginning point and there may not be an ending point. It could just continue up through trial. Other times patents might expire, or there could be just other activities that could truncate the length of the damage period. But in addition to looking at the impacted revenues, you want to make sure you have a clear understanding of what the damage period is. And then you can start making your projections as to what the but-for revenue would be, in the absence of the alleged infringement. Now, what's interesting here, and I'm just going to bring back in that other slide where we had, just sort of the mirror image of what the defendant might do. But frankly, the plaintiff would want to be preemptive of that. So it could very well be that the but-for revenue looks more like the green dotted line rather than the red dotted line. In other words, if we go way back to, the Great Recession, if that's when this damage period was, you might not have continued, at the red line pace. Everybody, there was, recession in the economy and everything else. Or, we can see this happening now with COVID-19, that instead of everybody going at the let's just say March 2020, level of increase in sales and using that to project the red dotted line, you've got to somehow take into account, the diminishment in overall economic activity, both at the macro level for the entire economy. And there's probably certain industries that have been relatively more impacted than other industries. And so you've got to figure out, are we going to be at the red line or are we going to be at the green line? And, I think there's going to be some difficult calculations coming up, in the damages arena, on a going forward basis to take into account both the macroeconomic environment, and by macroeconomic environment, I mean the entire economy, and, also industry specific. Now, there also can be the flip side, which is, I've always found that there's times that the economy is very resilient, and there's other things that may have thrived even in a downturn for other industries. So there may be times that this could be a positive for some industries. I'll just give you a cute little example that, as you can tell, when I was talking about, The Matrix and Armageddon, I'm kind of a moviegoer and I like to watch movies. And during 2020, I couldn't go to any theaters, but I discovered a drive-in theater south of Dallas that I would actually go to quite frequently. And there were huge lines of cars, of people that were moviegoers like me, that at this one outdoor drive-in movie theater, there were 6 different screens, and it was I had to get there early because of how crowded it was. But I'm just trying to use that as an example that you could have the counter position too, that it doesn't always have to be that green line. I mean, I suppose, the red line could have been higher, if there might have been some benefits to certain industries from some of the, the bad things that were happening. But all I'm trying to do here is just motivate, what you're trying to do on the, on the lost revenue side. Now, there's different ways of projecting lost revenues. So I'm not going to go into detail on all of these, but I would say most damage quantifiers will default initially in their thoughts to one of 4 different methodologies. Now there's hybrids and there's other things you could do. So don't say, oh, Dr. Ugone said there's only 4 ways to do this. No, these are common ways to do it. There's, probably these are the first ones you think of, but then you actually have to fit the approach to the facts and circumstances of the case. But various ways of calculating lost revenues would include what's called a direct computation approach, a before and after approach, or maybe a before approach, something called a yardstick or proxy or even benchmark approach, or a market share approach. A direct computation approach is, 5 customers were taken from me. I would have had those 5 customers. I can just directly compute, the sales that were taken from me from those 5 customers being lost. And so that's what I mean by a direct computation approach. The before and after approach is, if hopefully I can do this, but if we go back here, before and after would be, well, if I look at the sales pattern before the beginning of the damage period, maybe I can use that to project into the damage period, which is essentially what I was doing with the red dotted line there. So the after part would be backcasting or connecting the dots if you're doing the before, during, and after as a methodology. A yardstick approach is, can I use something else as a benchmark to give guidance as to what my sales would have been? And obviously the market share approach is applying, and we're going to get to this in a second, because that kind of goes to the Moreflow approach of taking a market share allocation approach to try to figure out what the sales would have been. So in other words, what you can do is figure out what the but-for market share would have been, and then apply that to, let's say, market or industry sales. And if you think about it, there's times that cures a lot of difficulties. In other words, if the market is going up and down, or if the market was going down, and if you can justify what your but-for market share would have been, but for the infringement, maybe even saying it would have been constant, then applying the market share to the industry sales that might be varying, you're kind of automatically taking into account, whatever macroeconomic or industry effects might affect the sales of the company. So you'd be assuming the market share is constant, but applying it to a different base. So it would take into account, changing economic conditions. That doesn't mean all of these are perfect. Like the market share approach may not fully take into account, new entry into the market that might have had an impact on the market share. So you still got to keep an eye on a lot of different things, but I'm just trying to give you an idea of different ways that you might, in a lost profits model, in a competitor-to-competitor patent infringement case, be able to come up with that lost sales analysis. Some of you are probably familiar with this, the Moreflow approach. So if you look at the left-hand side, that's sort of the actual market, where you've got the defendant in red, the red slice of the pie, having 20% of the market. The plaintiff is the darker blue, having 30% of the market, and then there's other competitors having 50% of the market. So the Moreflow approach basically says, look, if we take the infringing sales out and figure out the but-for market, and you do the proper calculations, which you see down in the note there on the right-hand side, that would mean that basically, the but-for market share of the plaintiff would have been 37.5% in this example, and 62.5% for the others. But that's kind of how this allocation approach works. And then you'd literally just sort of take that but-for market share and allocate the infringing units, according to that but-for market share. So you get the plaintiff's either lost unit sales or, lost revenues, depending on whether the market share is sort of a revenue-based, sales-based, dollars-based, or unit-based. But in its simplest form, that's how you would apply sort of the Moreflow approach, which is, frankly, a very common, a common approach. Now, a lot of people may know that, but I wanted in my next slide, so hopefully I remember my next slide carefully here. My next slide says, okay, that seems straightforward, but there are some landmines we have to be careful about. There are some potholes in the road. There are some secondary analyses you have to do. So this is another case where you just don't want to be mechanical. You don't want to take the cookbook approach. You don't want to just say, I'll just figure out a but-for market share and apply it to the defendant's sales, and that's how many sales I would have gotten. There's a whole bunch of other questions you should also look at to make sure it's even appropriate to be doing that calculation. The way I think about it is sometimes what a damage quantifier will do is they'll multiply A times B to get C without ever asking the question, should I even be multiplying A times B to get C? In other words, you've done the math right. A times B is C, okay, but should you have even multiplied those numbers? And that's the part where I kind of want to just elevate this maybe to a little bit higher level to make sure that you get some guidance that even if you're using a straightforward application of Moreflow, that you're thinking about some of these more difficult concepts. Now, so the title of this slide is, it may not be that easy, just multiplying A times B. The first thing is, and I'm going to go back for a second, but the first point I say there is the zero output assumption. So let's just go back. If you look carefully here, this but-for reconstruction of the market takes the defendant totally out of the market. And the question is that really an appropriate assumption to be making? Sometimes with some companies, you know, the zero output assumption is basically just assuming that the company was just going to roll over, die, and not have a product. And is that really realistic for the situation you're in? Will the company just exit the market or not? And so you've got to evaluate whether that zero output assumption for the defendant is appropriate or not. The next one has to do with price differences. And I'm really going to talk about that sort of in two different ways, that it's not uncommon, you know, that even though you can have a competitive situation and maybe products are competing against each other, but we all know that when we look around, there's differences in prices. It's not uncommon to have a distribution of prices in the marketplace. It's never true, or very hardly true, that there's only one price. You go to buy milk from Walmart, it's a different price from Circle K or 7-Eleven. It's a different price from Kroger or Brookshire's. So you've got different prices. And so the question is, are those meaningful enough such that that might have been an impediment to just saying that some of those sales, or my market share, but for a market share of sales, would have accrued to, you know, the patent holder in the absence of the alleged infringement, especially if there's significant differences in prices. So for example, if the defendant is charging lower prices and the plaintiff is charging higher prices, and the plaintiff is saying, okay, well, you know, but if the plaintiff's prices are 50% higher, you know, there's something called the elasticity of demand. In other words, what's the responsiveness or sensitivity of quantity demanded to a change in price? And if there's higher prices, you know, would all of those purchasers have switched over to the plaintiff's side or not? And so that's where things become very complicated. Now, you know, there's all kinds of additional complications coming in. I'm not saying you throw out Moreflow. I'm just saying here's things you need to think about and be prepared for when you develop a Moreflow type model to make sure you have answers for these issues. You know, one of my favorite ones is sometimes a plaintiff expert may just say, well, I'll just assume the defendant's prices or revenues. Okay, the defendant was charging, you know, 20% less, so I'll be conservative in my model and I'll just accept the defendant's revenues and use that in my projections. I won't use the plaintiff's prices or revenues. But that just creates additional conceptual problems. And the conceptual problems deal with the but-for reconstruction of the market. So is there this one segment that now gets 20% less prices? And what does that mean for your existing customers that in the but-for reconstruction, if they had found out that 37% of the people are getting this 20% lower price, what nightmares would have that created, for the actual purchasers in the actual world? So it doesn't always solve the problem of just saying, I'll assume the defendant's prices, because it may create, I like this old adage of you push one lever down and another lever comes up. That's what would happen here. I don't want to, take up too much time sort of just in this segment here before we move to reasonable royalties, but there can also be different types of customers between the plaintiff and the defendant. The plaintiff may, have small customers, the defendant may have large customers. Would the large customers have gone to the smaller, the small, to the plaintiff who's just dealing with smaller customers? Would that have happened? Sometimes there's customer specific, considerations that there may be reasons why certain customers may not have shifted. But I also don't want to make it seem like these are all deficiencies on the bad side for the plaintiff, because sometimes Moreflow, my last point here, will underestimate lost sales. In other words, if the defendant, which is not uncommon, is targeting the customer base of the plaintiff, the patent holder, then the Moreflow may actually underestimate what the sales of the plaintiff would have been. So it can actually go both ways. My point here is that even though some of these calculations may seem straightforward, in order to come up with a really defensible and reliable lost profits model, even if you're using a generally and well-accepted, Moreflow approach, as one example, there's a lot of layers down of things you want to cross-check to make sure, that there aren't any holes in the analysis that the defendant expert, may try to, take advantage of. This one real quick, when you're all done, you have to be careful that if you're making a projection of the lost sales of the plaintiff, as I said before, this is one of the Panduit factors, that you've got to look at production capacity, which is the left-hand bar of the two bars that are side by side for the various years there. And you've got to look at actual sales. Then you add on top of that the lost unit sales to get total but-for production, and then compare that to capacity and make sure you're not exceeding either 100% capacity or effective full capacity. So sometimes, even though, kind of boilerplate capacity may be high, there could be reasons because of downtime or maintenance or what's happening with various shifts that you may not get sort of that rated boilerplate capacity, and it may be something less. So full capacity utilization could actually be something like 90% of capacity rather than 100% of capacity. But you always want to keep an eye on this so you don't run into that problem as well. And so I just wanted to introduce, there's the simple concept of making sure that you're not producing more than capacity, but sometimes there's an issue of what is effective full capacity, which may be less than what I'm calling sort of the boilerplate capacity. There's maybe one more comment. I've spent, all this time talking about the revenue side, but there's also the cost side to get to lost profits. But I'm going to save that for another day. So that's sort of the teaser, on how one would do the, the cost side. But that's also a very important component as well, figuring out what the incremental costs are. And the only thing I'll say there is that there's, incremental costs for small increases of production, but then there's the incremental cost of large increases in production, which could take into account, adding more equipment, adding an additional assembly line, knocking down a wall and expanding the factory. So you've got to make sure you think through, all of those issues as well. But that's for another day. We're getting ready to switch over to the reasonable royalty side, but maybe I'll just take a breath, stop here, see if anybody's got any questions. I've been talking a lot and saying a lot of things. I've been trying to just really kind of just motivate some things for you to think about, at least on the lost profit side in a, competitor to competitor situation. We're now going to turn to the reasonable royalty, but I'll take a 30-second breather and see if anybody's got any questions they might want to ask.
Great, I'll just pop back in. Let everybody know that if you'd like to submit a question to Dr. Ugone, you can just drop it in the Q&A box at the bottom of your Zoom window. You can type it in and he will see it and can address it as they come in. At this time, though, Dr. Ugone, there are no questions.
Okay, so we'll keep going forward here. So I'm switching over to the other common measure of damages. Now, remember, I'm going to say, we talked about lost profits. We're talking about reasonable royalty damages now. I haven't specifically addressed price erosion, but that could happen on the lost profits side. So, just because of time constraints, I'm mentioning it, but that's a whole study in of itself. And I'm not going to bring reasonable royalty, or I'm sorry, I'm not going to bring price erosion into the reasonable royalty side, but it could come in as well here in terms of, that being a concern, that if you're a patent holder and you're, you could be licensing, I suppose, a competitor, or it could be a non-practicing entity, but there may be times that you want to kind of keep an eye on whether there can be a price effects if you license somebody that's that could be a competitor versus sort of the non-practicing entity side of things. But as everybody's aware, the base usually for reasonable royalty damages, when let's just say lost profits damages are not available, or it's not uncommon for a plaintiff to put a lost profits damage model forward, and then just as sort of a safeguard, in the alternative, if the court doesn't rule or the trier of fact doesn't rule that lost profits are available, they have the fallback position of reasonable royalty damages. Now, again, this is where you want to be careful with your damage quantifier that they don't fall into a cookbook approach. But everybody's heard of Georgia Pacific. There's the 15 Georgia Pacific factors. But before we get there, I think it's always good to keep in mind and not get stuck in a way of thinking that there's only sort of like one type of royalty damages, or that there's only one type of royalty payment structure, when in fact, there's many different royalty payment structures that we see out in the real world, ranging from lump sum payments. Now, a lump sum payment is, we don't want to get too fancy in our terminology here, is independent of the level of use. So in other words, there could be a license agreement where whether I use it at all, the technology, if I'm the licensee, or whether I use it just a little bit, or whether I use it a lot, there's a lump sum payment that does not vary depending on how much I produce. And that's called a lump sum payment. And it could either be an upfront payment, or, maybe you agree to pay X amount per quarter or X amount per year. So it can take a couple of different forms, but if it's independent of the level of use or independent of the level of output, we would call that a lump sum payment. On the other end of the spectrum is what's called a running royalty rate, where that does depend on the level of use, or does depend on the level of output, or does depend on the level of sales. In other words, the lower the sales, the lower the payment, the higher the sales, obviously the higher the aggregate royalty payment. Now, the only thing I might mention here is that, again, there's a couple of different options. There can be what's called a per unit royalty payment, which is a dollar amount. In other words, you pay $1 per unit sold. So that's a per unit of output royalty payment, but it's a running royalty rate because it's dependent on the level of sales. But there could also be, per dollar of revenue, which is a percentage based, where instead of saying, okay, I'll pay you $1 for every unit I produce and sell, I'll now pay you 10% of the revenue I take in on the units and I sell and the associated revenue. So one is a dollar amount per unit, let's say, and the other is a percentage of sales. So all you need to think about is, what's appropriate for the facts and circumstances of the case, and don't just, fall into the trap of thinking that there's only one type of royalty payment structure, when there's actually, many different royalty payment structures. And frankly, there's hybrids of all of these. It's not uncommon that you might see an upfront payment plus, a running royalty rate. So, I've seen that quite a bit as well. So that's just a little background on the royalty payment structures. I'm not going to, don't get worried. I'm not going to go through all 15 factors. And that's also what I usually tell a jury. By now in a jury, in a jury trial, by the time somebody's gone through all the check marks on the infringement, testimony, and by the time you're almost an hour in on the damages, and then somebody puts up, 15 factors, they're kind of going, oh no, so what I usually do is try to just, narrow these down to what's important for the case. But I think what I'm going to focus on here, kind of in our remaining time, and I'm supposed to only have till 10:30, but I think we also have a little bit of a break. So I may go, if it's okay, Roy, I may just go a little bit beyond my 10:30 cutoff, unless you tell me, unless you like pull the plug. But I'll try to go through this quickly.
The floor is yours.
As people know, in reasonable royalty damages, it's not uncommon to have a hypothetical negotiation construct. And the hypothetical negotiation construct is basically, look, you've got a situation where you've got to determine what a reasonable royalty payment is for the use of the patented technology. A license agreement in the real world was never executed. So we have to simulate what would have happened if the parties had negotiated, and if they had come to an agreement, what would that agreement have been within the hypothetical negotiation construct? Now, I think that the hypothetical negotiation construct in many ways should mirror what would have happened in the real world. You're still using some of the same facts and some of the same circumstances, but the difference is, in the real world, the plaintiff can, or the patent holder can go, you're not willing to pay enough, and go storming out of the room, and they don't reach an agreement. Or the defendant could say, well, you want too much, and go storming out of the room. That cannot happen in a hypothetical negotiation. In a hypothetical negotiation, you have to come to an agreement to give that guidance to the trier of fact as to what reasonable royalty damages would be. So there are certain assumptions. Usually the hypothetical negotiation is at the time of the first alleged infringement. And you can really kind of package that two different ways. One, so they don't break the law. If that's at the time of the first sale, in other words, at the time of the alleged sort of first infringement, they would need a license agreement to not run afoul of the patent infringement laws. Or you could even describe it as just sort of a business consideration, that I want to produce a good, I want to use your technology. And so from a business perspective, I would need a license before I start selling. But that's, what the courts have assumed is the date of the hypothetical negotiation is at the time of the alleged first infringement, or when you would have needed a license to the patents in suit. Other assumptions are that the patents are valid, enforceable, infringed. If you don't have that assumption, there's no need for the calculations. But you do assume that the parties are willing negotiators, that they're smart, prudent, well-prepared business people going into those negotiations with reasonable knowledge in order to negotiate an important business contract. that's the way that I like to kind of phrase it, that they've got to go in smart and have all the facts at their disposal. And that's why when you're doing your Georgia Pacific analysis, you don't just sort of do this check mark approach and cookbook approach of going through the 15 factors. You really need to think through, what would the two sides as prudent, smart business people take into account when they're sitting down to negotiate a very important business contract. And like I said, the parties must reach an agreement. A lot of times, one approach to ultimately coming up with a reasonable royalty rate is to sort of look at license agreements that may exist. And so that's why I kind of highlighted factor 1, factor 2, and factor 12. Factor 1, are there any license agreements related to the patents in suit? Does the licensee have any comparable license agreements? And then also factor 12, are there any industry royalty rates for the use of comparable technology? The point here is this is almost like a yardstick or a benchmark or a proxy approach. In other words, are there license agreements out there that can give me guidance as to what the value of these patents in suit are equal to? Now, you have to be a little careful with factor 12, because I would say that's a little bit more dangerous nowadays, because you really need to make sure, and I'm going to turn to the next slide here, that you've got to make sure you do the proper comparability analysis. And there's really sort of technical and economic comparability. Whenever I'm trying to explain this to the jury, I give a very simple example. I mean, it's kind of like when I talked before about when I'm testifying in the Eastern District of Texas, and the issue is, do I take Interstate 20 to get to trade days, or do I take Highway 64? I got my choice. That's something they can understand. And so I always give, the house example that, I explain to the jury that if you want to sell your house, or frankly, if you want to buy a house, if you want to sell your house, what's the first thing you do? Absolutely, the first thing you do is you see what the neighbor sold their house for, or what did the house down the street, what did it sell for? Well, that's the same thing here with license agreements. But you've got to make sure that there's technical and economic comparability. Now, I'm not an attorney. I can't speak about rules of evidence, but it's just my experience as a damage quantifier that this is what the trier of fact and the courts are looking for, to make sure there's technical and economic comparability. And that's where, I'm coming full circle to what I said at the beginning in terms of, damages being a team sport, because often the damages expert can deal with the economic comparability, but may not be able to deal with a technical comparability, and likely cannot deal with that. And that's where you need to bring in the technical expert to assist the damage quantifier to make sure you have something that's technically comparable. Then you can make sure that the economics are comparable. Then you can draw some guidance as to whether these proxy or yardstick or benchmark license agreements will give you guidance as to what the licensing value is of the patents in suit, just like will the neighbor's house give me guidance as to the value of what my house is. So that's the way I would describe that.
Dr. Ugone, before you proceed, we did actually have a question come in. I want to point your attention to it before we get too far away from the topic.
Okay.
So it's a question about apportionment, and I want to see if maybe you can pull it up so you can address it directly. I can show you how to do that. If you just go back to your Zoom window, you don't need to stop sharing, although you can if you'd like to.
Well, I pushed on the Q&A, and I think I have a question here. I was going to get to apportionment a little bit later, but let me read the question. I'm going to read it to myself. It's a long question. Let's see here. Wow. Okay. So let me see if I can address this. So let's say the question's about apportionment, and the question is about methodologically how one might apportion. And then it gets a little bit more specific about, can you use regression analysis to help with the apportionment question? You know, I've got some strong opinions about apportionment. Apportionment is very, very difficult. So the way to think about it, just to help out some of the audience, and I appreciate the question here, and it's a nice one to think about because it's got a lot of dimensions to it. But one way to think about it is think about a multi-featured product or a multifunctional product, and there could be just one component of it that allegedly infringes a patent. And so the question is, how do you isolate out or parse out, you know, that portion of the value of a product that's really due to the patented, you know, the patented technology versus everything else? And the question here talks about the use of regression analysis. Regression analysis can get very complicated. Regression analysis is the application of statistical techniques to economic problems. And one way to think about it is you can get a whole bunch of data and you can say, okay, I'm trying to understand X, and X is a function of and is determined by a bunch of other things, A, B, C, D, E. And one way to try to tease out the relationship, so you've got X is a function of A, B, C, D, and E, but you want to know how much does A, not A, B, C, D, and E, but how much does A contribute to X? So one way to do that is a regression analysis, and it's a statistical technique that looks at variations in A, B, C, D, and E and tries to correlate those with variations in X. Now, this is getting a little complicated, so hopefully you can follow what I'm saying, but there's a statistical technique that does that. It gets very, very complicated. It is an interesting technique here. It does bring in the complexities of getting the jury to understand it. Plus, I would say the biggest danger in regression analysis is it looks really scientific, but there's still an art to using a regression. So just because someone's using a regression and it looks like it's high-powered statistical techniques, that doesn't mean you're capturing all of the what I'll call the explanatory variables that explain how much X varies. So there could be that problem. There could be, you know, there's goodness of fit measures, something called an R squared, and that can range from 0 to 1. A 0 is bad, that it doesn't explain much at all, to a 1 that it explains it perfectly. And let's say you get a 0.4. So that's saying, hey, my model is only explaining 40% of the movement in X, this value here. So am I going to rely upon that or not when there's 60% that's not being explained? I mean, these are all sort of you know, I know I'm going to get quoted on this later, but these are all sort of the dirty little secrets of, you know, regression analysis. And then in regression analysis, each of the individual variables, you can kind of look at their statistical significance and whether they explain movements in the variable of interest. So what I'm saying is it's an interesting technique. I haven't seen sort of the exact regression equation or what the summary statistics were to independently evaluate how good of a job it was doing. But you've now just opened this whole new area of economics and econometrics that has to be explained to the jury. So I know the person that asked the question. I won't say their name, but I appreciate the question, and maybe hopefully I gave you enough of an answer there. But that's kind of off the top of my head. And now I can breathe a sigh of relief. It says no open questions. That was a tough question. So I'm going to go quickly here, but remember what I said before. Let's see if I can get control of my screen back. So here, remember I said you've got to look at technical and economic comparability. Well, just like there's two different houses there, it's not always a situation that the house next door or the license agreement that you have is a perfect match for your house or what you're trying to license with your technology. So it's not uncommon that you've got to make adjustments. And so I'm just giving you things to think about here. I'll go quickly because I've already run over. So I don't want to overstate my welcome. And I know everybody would like a break, especially after this lengthy discussion. But you can make economic adjustments dealing with the license term, the license sales, the geographic scope. Or it's not uncommon that the license agreements are more portfolio agreements, and you're just trying to figure out, one or two patents. So those are the types of adjustments that you have to consider to make sure you have economic, kind of comparability. The other thing that I want to bring up real quick is make sure in your analysis, and again, my point is don't just do a cookbook approach. You really need to think about these, and you need to balance the various contributions of the parties. What's the patent holder bringing to the table versus what the defendant is bringing to the table? And what you'll see on the defendant side is they're bringing their brand name, they're doing the research and development, they're doing the marketing efforts, they're commercializing the product, they have the relationships with the customers. And then the question becomes, the defendant's going to be saying, hey, the only reason why there's sales is because of the efforts the defendant is making, and why should I pay you for my own efforts? And the plaintiff is going to say, well, but my patents and my technology is an integral part. It may not be the driver of sales, but it's an integral feature in the product you have, so you wouldn't have as good a product. So those are just some of the things to be thinking about. Last thing, just real quick, and then maybe I'll just end it here, is the issue of acceptable non-infringing alternatives and how that can put a constraint. I don't like to say a cap on the royalty payment. I like to say a constraint. And I'm going to end with an interesting mnemonic here. Nomenclature facts. If you're as old as me, you remember Dragnet and Sergeant Friday just asking for the facts. And so what I would encourage people to do is when they're talking about acceptable non-infringing alternatives and when it's appropriate or not, just think of the facts. Now, what do I mean by that? The F stands for, is the non-infringing alternative functionally equivalent? Now, not infringing, but is the alternative functionally equivalent? The A, is it acceptable? The C, is it not cost prohibitive? T, does the timing work with when it would be needed? And S, are there any switchover costs? So I'm not saying that this answers every question, but I'm saying this is a nice home base that I always start with when I'm trying to evaluate acceptable non-infringing alternatives. Does it meet the facts? Is it functionally equivalent, acceptable, not cost prohibitive? Does the timing work? And are the switchover costs, manageable or relatively low? I think I'll stop there. I appreciate everybody's, allowing me to talk today. And, if there's any questions, just, feel free to ask either now or you could talk to me later.
Great. Thank you very much, Dr.